Welcome back to the Wiley Ryan's Government Contracts podcast. Your co-hosts Craig Smith and Brian Walsh are here. And Brian, it's our first podcast of the new year. When we last left you, your baseball team was in the process of not winning the World Series. Tough winter for you in football and hockey. So really, your sports hopes are hinging on the continued production of a guy nicknamed Bodega Cat. And what I was thinking about, that's a perfect lead into today because you are the biggest cat person that we all know. And cat is a wonderful anagram for today's topic, the CTA. So we're here to talk today about the Corporate Transparency Act. How do you like that?
I love it.
And our guest to talk to us about the latest with the Corporate Transparency Act, first our colleague Vesna Harasic from our White Collar Defense and Government Investigations Group. Vesna, thanks for joining us.
Thank you for having me.
And also Ira Mirsky, an attorney in our corporate practice. Ira, thanks for being here as well.
Thanks. Happy to be here.
So the CTA, the Corporate Transparency Act, came into law in 2021. There's been plenty of development and hand-wringing. And at the last quarter of the year, plenty of excitement. And now many companies, including government contractors, some are saying, what is this? I saw a whole lot of news about it in December and January. Some are saying, what do I do now? And that's what we want to talk about today. But first, I think for those who are in the what is this, maybe Ira, could you just give us a quick overview of the CTA for those who haven't been following it as closely?
Sure. So the Corporate Transparency Act created an entire new reporting requirement for businesses of virtually any size where you are an entity registered to do business with a state or organized under state law in the United States. And depending upon the relative complexity of the organization, from a mom and pop corner dry cleaner that organizes as an LLC to a complex multi-tiered entity, each of these entities could potentially be subject to reporting, and ultimately it requires drilling down to identify the individuals who are the ultimate beneficial owners. And for the more complex organizations, this could be a potentially invasive and certainly labor-intensive exercise for compliance.
Where does this reporting go?
So this reporting goes to an online database, and depending upon your confidence in our government's secure database, it's supposedly going to be a secure database that will have limited access for appropriate enforcement objectives. And the enforcement objectives are ostensibly that these shell structures create perfect opportunities for criminal enterprises, for terrorist financing, and for other folks to hide in the shadows. Just like with registration of handguns, you can sort of use your own sense of whether these criminal enterprises are going to comply with reporting to begin with, but it's ostensibly going to add transparency to the structures that would otherwise be an opportunity for concealment.
And the database, is that where I see, is it FinCEN? That's the activity where they're going?
Correct. So the U.S. Department of Treasury has an agency, the Financial Crimes Enforcement Network. This is an agency that, among other things, oversees a broad spectrum of money laundering, Bank Secrecy Act reporting, and now the Corporate Transparency Act, all of which are ostensibly to address financial crimes.
So I'm a government contractor. I do business with Uncle Sam. I'm subject to all sorts of vetting. Where do I fit into this picture?
Under the Corporate Transparency Act, there are 23 categories of organizations that would potentially be exempt from these reporting requirements. Some of the most common examples would be if you're an SEC reporting company, you're already subject to a significant level of oversight. If you are a Section 501c of the Internal Revenue Code tax-exempt organization, you are also subject to a extensive level of oversight. If you are a large operating employer, and that has both a financial parameter as well as a number of employees parameter, you may also be exempt. So some government contractors will be exempt. But where this trips, in many cases, is not only whether your entity is under one of these 23 categories of exemption, but also, again, if you have a complex organizational structure, you may have some entities within your structure that are not covered by this umbrella.
Like a joint venture?
Correct. And so, for example, for the large operating employer, the employee parameter is entity by entity. You don't get to aggregate. And so that's been one particular area of tremendous heartburn for the analysis.
I was going to add, I think that where the CTA is going to come into the picture for government contractors is your small business government contractors, because as Ira said, your large operating company exemption that has 3 different factors that you're looking at: 20 full-time employees, physical presence in the United States, over $5 million of gross receipts in revenue and sales. So a lot of your government contractors, your large ones, are going to fall under that exemption, but your small business contractors, ones that are in some sort of SBA government contracting program, they're really going to be subject to the CTA and the filing requirements.
Well, I'm sure this hasn't caused much consternation or anything in the industry, Vesna. I mean, I'm guessing, though, there probably might have been some litigation and maybe some other challenges, given that, in my experience, anything with 20-something exemptions usually leads to someone suing about something. Has that occurred here as well, Vesna?
Yeah, so there's been a good amount of litigation this past year. Most of it has been either small businesses or small business organizations bringing challenges in various district courts in the United States regarding the constitutionality of the CTA. And we can talk about that in a second, because I think that leads us to our more relevant conversation, which is what is going on with the CTA right now. But in terms of the actual requirements, how they're being interpreted, we haven't gotten to that litigation yet, because there are all these constitutionality challenges. What is the CTA even constitutional? And so that's where the litigation has focused. But if the constitutionality of the CTA is ultimately upheld, I think that there will be litigation in the future in terms of actually arguing over the nuances of these exemptions and do I qualify? Do I have to report? Do I not have to report?
So we haven't even gotten over the threshold yet. We're still arguing about the applicability or even ability to even whether or not this law is even valid versus all the nuances that will be litigated for years and years if it's found to be valid. And I guess that's all comes out of Texas right now, most of it, or
Yes.
the main one?
Yeah, so to give a little history of the litigation, there's been litigation over the past year, and there have been challenges in different district courts: District of Oregon, Eastern District of Virginia, Northern District of Alabama, and then the one that's gotten a lot of notoriety recently, the Eastern District of Texas, which I'll talk about in a second. But these challenges, they've had mixed results. So I think in the District of Oregon, for example, they were looking for a preliminary injunction to enjoin enforcement of the CTA, the plaintiffs in that case. And the judge actually denied the preliminary injunction, saying, among other things, that the CTA was likely to be found constitutional. So there's been mixed results. The Northern District of Alabama is the only, well, besides Eastern District of Texas, which we'll talk about in a second, but the Northern District of Alabama was the only district court that had issued a preliminary injunction saying that the CTA was likely unconstitutional, but that preliminary injunction only applied to the plaintiffs in that case.
Oh, so not nationwide, okay.
Not nationwide, exactly. And so where the reason why you've seen so many CTA alerts recently and you've seen all these thought leaders coming out trying to predict what's going to happen with the CTA is that all of this, in my mind, blew up in the beginning of December when we're about a month away from a key CTA deadline. So that deadline was the January 1st, 2025 deadline, where basically any company, any reporting company that was formed before 2024 had to file their beneficial ownership information report by January 1st, 2025. So early December, the Eastern District of Texas, in a similar constitutional challenge by a trade organization and I think another small business in a case called Texas Top Cop Shop versus Garland, that court, the judge in the Eastern District of Texas, actually issued a nationwide preliminary injunction. And that affected all companies out there saying that the government cannot enforce the CTA. So it effectively put the CTA on a pause.
And there was some yo-yoing, wasn't there, Vesna,
Yes.
around the new year on whether the injunction was itself paused?
Yep. So, of course, the government appealed that. So they appealed the preliminary injunction decision to the Fifth Circuit. They also sought a stay at the same time. And the yo-yoing was essentially the Fifth Circuit. I believe they have 17 judges. And there's a panel that reviews only stays. And then there is obviously your merits panel that is going to review the actual decision here, which was the appeal of the preliminary injunction. So you had a stay panel actually overturn saying that the preliminary injunction was off. Mm-hmm. And so the requirements were back on. And that was on Christmas Eve that happened. And then a few days later, I believe on the 27th, Ira, keep me honest here, the 26th, the case went to the merits panel who said, okay, we have the preliminary injunction appeal now, and we've decided actually that the preliminary injunction is back on, meaning that companies do not have to report. And mind you, this is days before this January 1st, 2025 deadline. There haven't been, I believe there's been, as of yesterday, only 10 million companies that have filed these beneficial ownership information reports out of an estimated 32 million. So you can imagine there's a ton of companies out there during this time that did not know what to do. The requirements are off. We don't have to file our reports. The requirements are now on to being off again.
And if I recall, the Fifth Circuit sent an accelerated briefing and argument schedule?
They did. And so their briefing schedule is in February, and then they have set oral argument for March 25th.
And so let's take a pause here while we think about this briefing schedule to hear a word from our sponsor. Today's Government Contracts podcast is brought to you by injunctions. Whether preliminary or permanent, just the parties or nationwide, injunctions really put a pin in it.
Waka waka. I like that. And obviously injunctions are not injunctivitis, which was a sponsor we turned down just because it really didn't mesh with us and didn't fit in. And I was really kind of sad about that, but no matter how much they wanted to pay us, injunctivitis was just not a good sponsor for this podcast. Now, the stays are currently in place. Obviously, you had the Christmas Eve miracle if you were the Department of Justice, and then you had the, I guess, Hanukkah, second night of Hanukkah miracle if you were the plaintiffs who got the injunction back 2 days later. Now we're in a stay territory and nothing's going on, or the deadline's already passed. Ira, what are we telling people? I mean, there's a deadline, it's passed, there's briefing into March now. What the heck should we be telling companies to do?
Well, that's obviously the $100,000 question, Brian. There are certainly many practitioners out there that are conservatively telling companies to continue to do the work to be ready to push the button to file in the event that the law is ultimately upheld and there's a very short runway to get that filing done. The dilemma for many of the clients that I'm working with is, again, they are a fairly complex organizational structure. In some cases, some of the questioning is potentially invasive, as we'll talk about some of the more nuanced issues, particularly if there are community property and so spousal interests. And so for all of it, it's, do you want to assume you're going to have to do this and do the work, pay the attorneys? The best practice, and I think the single most important advice for anyone that hasn't done the filing, is to at least do contemporaneous documentation of your thinking, your efforts, especially any counseling with attorneys, financial advisors, so that you have prepared evidence to at least demonstrate a reasonable good faith effort that you're not willfully ignoring, because that's really where the teeth of the penalties for noncompliance come.
So, yeah, I think it's an interesting dilemma because, as Vesna was mentioned, at least in the government contract space, it affects a lot of small business government contractors who may not want to spend money on lawyers and other things necessarily for something that may or may not happen, and it sort of puts everyone in a bad spot. But I think the contemporaneous documentation point's a great one, because at least then you have something.
Well, and one thing that comes to my mind too is we've seen a trend with challenges to executive orders affecting government contractors of the appellate courts narrowing injunctions to just the parties before them. And Vesna, you mentioned the Northern District of Alabama. I mean, I suppose one very possible outcome here is the Fifth Circuit Merits Panel says, we agree that this law is likely unconstitutional, but we're narrowing the injunction to the parties that were before the court. And so thinking about those, I'll throw this out for either of you. What do you do to be ready for that scenario? Or what, beyond documenting your contemporaneous thinking, are there other steps that contractors should be thinking about for that scenario?
So I actually will add the most recent on the litigation is now there has been an emergency application with the Supreme Court. And so this Fifth Circuit merits decision saying that the preliminary injunction is back on while the appeal is pending, that has now been appealed to the Supreme Court. Justice Alito, he is the justice that is in charge of all Fifth Circuit matters, and he actually ordered the plaintiffs, the respondents in the case, to file their brief tomorrow. So we'll know more whether the Supreme Court is going to actually once again overturn the preliminary injunction while the appeal is ongoing, and whether that's going to have this CTA deadline back on. Although Brian and Ira made the point that we're past the January 1st, 2025 deadline. So at this point, if the requirements are reinstated, there is going to have to be some additional guidance from FinCEN as to what the new deadline is, because that deadline was in the CTA, in the statute itself.
And two additional comments. One is that the language of the statute for the deadline is a little unique, because instead of specifying the date, it says no later than 1 year anniversary of the effective date, which was 1/1/2024. So it's a different mechanics administratively to move that filing deadline further down the field.
And what was the 1/1/2024? What's the trigger date that you're referring to there for our listeners?
That's the effective date for the Corporate Transparency Act.
Okay. And so the question is, well, what do you do if, it's like lifting the cover over a pie or something? What do you do if that happens in March or June? And it sounds like FinCEN would have to give some guidance just to bring order to a lot of uncertainty.
Right. And I imagine FinCEN would give some sort of grace period because we're over the deadline. I don't know how forgiving they're going to be. When all of this Fifth Circuit litigation was going on and the preliminary and the CTA reporting requirements for that little period of time were reinstated, FinCEN did come out and say, we're going to extend the January 1st, 2025 deadline to January 13th, 2025. So gave a little bit of a grace period there on that deadline and then some other deadlines on the CTA. But so I would imagine that if the Supreme Court ultimately decides to reinstate the Corporate Transparency Act reporting requirements for businesses, that FinCEN is going to come out and say you have set number of weeks to get your reports in. But I don't know that they're going to be that forgiving. Again, this is speculation, given that even the initial extension that they had was only 2 weeks. So they really want I think it's in, back to Ira's point, in companies' best interest, especially if they have more complicated structures, to get all that prep work done and really just get it all done up until the point of send and wait to hit send until we know more.
Well, I'm sure we've got some listeners who are saying, well, we have a new administration coming shortly. They've got control of all three, the two houses and the White House. What are the odds that this CTA goes away before a court can do much of anything with it?
Well, so that's a great question. I mean, obviously, we would be on a very different pay scale if I knew the answer to that. But I think there's an interesting question, both whether the administration can and will pull back the Corporate Transparency Act completely. Bears noting that in the finance bill, just for the end of the year to keep the government funded, there was originally a provision to move the filing deadline out to January 1, 2026. And when that was pared back, they stripped that out. I don't know exactly what insight that gives the administration. But the other thing is, rather than actually pulling the statute, it's also a question of whether the administration could simply tell the new Secretary of the Treasury to tell FinCEN, don't enforce the Corporate Transparency Act, and then at least that moves it down the field, law still in the books, but for the next 4 years.
I think it's important to look at the legislative history here for the CTA. Now, we don't know what Trump is going to do, and I don't think he has come out and said what his formal opinion is on the CTA. There was speculation when Project 2025 was talked about during the election season. Project 2025 actually calls for the repeal of the CTA. So there is some speculation that that is where Trump is leaning, but we just don't know what his policy is going to be on the CTA come January 20th. And I'll talk about that. And if DOJ and the Trump administration decide not to enforce the CTA, I'll talk about that in a second. But looking at the legislative history in terms of what is the likelihood that the CTA is going to be repealed, we also don't know. But if you look at the legislative history, the CTA was passed in 2021 by a Republican Congress. It was part of the annual defense spending bill at the time. So it was just an add-on there with more important issues, I'm sure. And Trump actually vetoed the law, but I don't believe that he cited the CTA as a reason for vetoing it. And then Congress overrode that veto, and that's how the law came into effect. So I am no legislative history expert, and I will not make any predictions right now about what is to happen with the CTA. And there is some legislation out there, I believe, I forgot the name of it, that is looking to repeal the CTA. But I don't know necessarily that that is going to happen. And if it does not happen, if the CTA is still on the books, but the Trump administration decides not to enforce it, then you always have the risk as a company to not abide by the CTA, even though it's on the books. And then 4 years from now, if maybe there's an administration change that all of a sudden wants to go after companies that did not file their reports during the Trump era, could actually get you in trouble because the CTA is technically still on the books.
Or the administration could change its mind.
That's true.
2 years from now.
Mm-hmm.
So it sounds like we should all be aware of this possibility, but maybe not count on it, is what I'm hearing from you both.
Yep.
Exactly.
And just one thing I wanted to add, when Vesna mentioned earlier that the briefs were due at the Supreme Court tomorrow for the plaintiffs, for those not in our live studio audience, that tomorrow would be January 10th, 2025. So the briefs are due on January 10th. Obviously, those here with us will know what day we're recording this, but in case you're listening to this in your car, your iPhone, your Sony Walkman somehow, we just want to get that date out. And it'll be interesting to see. It's very hard for me to tell what the Trump administration's priorities are, with so much coming out, but we'll see. I mean, after Greenland, maybe we'll get to CTA. I don't know.
A lot to look forward to, I think, is how we can button this up. So, Vesna, Ira, thank you so much for joining us. It's a pleasure having you as guests for the first time on our podcast, and we look forward to seeing more as these developments unfold in 2025.
Thank you.
Yeah, thanks very much for having us.
Wiley Ryan's Government Contracts podcast is co-hosted by Craig Smith and Brian Walsh. Our executive producer is Tracy Winfrey Howard. You can find this and other episodes on Apple Podcasts, Spotify, and at our website, www.wiley.law.